Rolling.
On a record. Good morning, I'm board member Stacy Moniz, and I'll be presiding over today's proceeding. Also present are board chair Marcus Oshiro and board member Cesnita Moipono, who is appearing by Zoom. Today is January 23rd, 2024. It's approximately 9 a.m. And we are here today regarding case numbers 23 CE 05976, 23 CU 05 400, 23 CE 05978, and I know there's one more. It's 23 CU 05 398. It's in the matter of David Reid. Sorry. Sorry, excuse me once. Documents. It's in the matter of Donna Campbell, David Reid, and Cecily Thirty's Best against as complainants and respondents are the Department of Education, State of Hawaii, and the Hawaii State Teachers Association are the respondents. This is day 2 of the hearing on the merits. Would each party or their representatives please enter their appearances for the record, beginning with you, Mr. Reid.
I am David Reid, and I am representing the complainants.
Thank you. And also present with you, if you can enter your appearances, please.
Donna Campbell.
Thank you.
Cecily Best.
Thank you. Mr. Takei.
Morning, board. Hiroyuki Takei for Department of Education.
Thank you. Good morning.
Martin Kiani Alapa for responding HSTA. Also present is Deputy Executive Director Andrew Eshelman for HSTA. Thank you.
Good morning, Mr. Alapa. Good morning, Ms. Eshelman. I believe, well, first, before we go on, are there any issues that need to be raised before we proceed with our witness? Mr. Reid?
No issues.
Mr. Takei?
No.
Mr. Alapa?
Nothing from me. Thank you.
And my recollection was we were continuing with Mr. Bacon as a witness. Is he here?
Yes.
Okay, can you, Mr. Takei, can you be kind enough to bring him in? Hey, good morning, Mr. Bacon.
Good morning.
I'll remind you that you're still under oath.
Thank you.
Just before proceeding with any questions from the board, Mr. Reid, do you have anything further for Mr. Bacon at this time?
A couple questions. Are you aware of the department's efforts to speak with the lawmakers when it came to drafting both the budget and when it came to drafting the budget to include the money for compression?
I was not involved in any of those discussions.
Are you aware of the legislature's willingness to fund compression to fix this problem?
I am aware that they were wanting to help fix this problem, and I think that was the intent of the bill that was eventually passed by the legislature.
Was the department ever given a limit to how much money that they could spend to solve compression?
I'm not aware if a limit was ever given, no.
Okay. When it came to funding the up to 6 years of prior experience for BU5 employees, Is it still your testimony that you couldn't afford to fund those 6 years?
I don't,
Objection, that misstates Mr. Bacon's testimony yesterday.
Mr. Reid, can you rephrase your
Yeah.
question, please?
Was it your testimony yesterday that the money was not in the budget for those 6 years?
that was not my testimony that the money was not in the budget.
So, were there any issues with the funding for 6 prior years of experience?
The issue of the 6 years of prior service, it wasn't necessarily a funding issue. It was more of we were trying to fix the compression issue for those employees that were employed with the department that didn't receive pay. And that, again, that's why the 6 years of service was not considered for those that were not employed with the department at that time.
Which periods of time was compression concerned with? Sorry, that's a little vague. Which periods of time was the department concerned with solving compression for?
I think compression was there. We were trying to solve it for all of our employees that were currently employed. And I think part of the eligibility criteria was that you had to be employed at the end of school year 21 and the start of school year 2022. And basically, we were looking at all employees that were employed during that time period to be eligible for this compression adjustment.
No more questions.
Thank you, Mr. Reid. Mr. Takei, you have anything further for this witness? I know you reserved.
Yes, same, I reserve my questioning for when the employer puts on its defense.
Thank you. Mr. Alapa, you have
No
any-
questions.
Thank you. Let's see if the board has any questions. Board member Moripono?
Hi, yes, I do. Hi, good morning, Mr. Bacon.
Morning.
Okay, look, yesterday you had said several times that both sides agreed to not include the outside years of service. And I assume that both sides means DOE and HSTA, is that correct?
That is correct.
Okay. When you say agreed, is there something in writing where HSTA actually agreed to not include the outside years?
I understand, and I believe that HSTA did put some information on their website to inform their members of who would be eligible, who would not. And to my recollection, I believe some of that information about the outside years of teaching experience was posted on their website for their members to see.
Okay, that wasn't really my question. My question
Oh,
was,
okay.
there was a written agreement with DOE and HSTA agreeing to not include the outside years of service.
I don't think that there's an actual written agreement on it, no.
Okay, so it wouldn't surprise you if I told you that Ms. Eshelman had testified yesterday that they did not agree to F2, the use of F2. That was a discretion by the employer.
So in the end, the employer did choose to use 899 F2 as the authority to implement this.
Okay, and Ms. Eshelman also said that under F2, that's the DOE's discretion. Do you agree?
Yes, I do.
Okay. Now, I think you said, and correct me if I'm wrong, that the years that there was compression was supposedly to address were from 2008 to 2018. Is that correct?
Approximately in that time period, there were no step increases that the HSTA members got. So what we were seeing with some of the data is that there was a large amount of employees that were in this certain range, and it was mainly due to that time period.
Okay, so if and I'm going to call them an outside BU5 teacher only because they were given credit for outside work prior to being employed with DOE. Okay, so if an outside BU5 teacher was employed during 2008 to 2018, did that BU5 outside BU5 teacher get compensated for their employment during that time? Did they get a step up?
So when the BU5 employee was hired, depending on the year that they were hired, if they did have up to 6 years of outside teaching experience, we would evaluate that information. And then based on the way it's written in the contract, we would place them on the appropriate step. And then that would then align them. From there, we would have followed the collective bargaining agreement between that, time period of when they were hired, if it was in 2008, for example, moving forward. And they would have received any of the collectively bargained increases that were afforded to them during that time period.
Okay, let me clarify my question because that really wasn't my question. So in 2022, DOE was appropriated some money to compensate those teachers that were employed during 2008 to 2018 because there was no pay increase at the time. Is that correct?
There was no step increases during that time period.
Okay, so if I was an outside BU5 teacher, but employed during 2008 to 2018, did I get compensated through that 2022 appropriation?
So if you were actively employed at the last day of the 2021 school year and the first day of the 2022 school year, that did determine that you were eligible for this compensation adjustment. And then from that period, we looked at how many years of bargaining unit 5 experience that you had overall. And then every year of bargaining unit 5 experience, every 2 years of it equated to 1 step increase. But we did not include the non-BU5 experience in part of that step increase. They got the up to 6 years for initial placement, but beyond the initial placement, the formula only allowed for bargaining unit 5 experience to be considered for the compression adjustment.
Okay, so in essence, there were some outside BU5 teachers that were employed between 2018 to 2018 who didn't move up. Is that correct?
If they were employed from 2008 to 2018, for example, that would have been 10 years of bargaining unit 5 experience for that 10-year period. Every 2 years of bargaining unit 5 experience that they would have had would have allowed them to move up on the salary. Yes.
Oh, okay. And then regarding the same subject, did a BU5 teacher that would have, I guess that was the target of the compression appropriation, who started in 2019, did that BU5 teacher get a step up? under the compression appropriation?
So if they were employed with the department from 2019 up until the time that that adjustment was made, what we were looking for is they had to be employed at the last day of the 21 school year, the beginning of 22 school year. If they would have had at that point more than 2 years of bargaining unit 5 experience, that would have allowed them to have at least 1 step increase.
Okay, so even though they didn't suffer under the 2008 to 2018 period, they still got a step up.
As long as they were employed in bargaining unit 5 and had at least 2 years of bargaining unit 5 experience, allowed them to then to move up at least 1 step.
Okay. Let's see. I think there was a question from Mr. Reid asking you how much the compression actually costs DOE, and you said you didn't know. Is that correct?
I think our overall request to the budget and finance was, I think we asked it in the range of approximately 55 million for the compression to be released from BNF for it.
Okay, and do you know if all of that money was used?
So there was an appropriation of approximately 121 million from the legislature for compression and other cost items. When we made a request to BNF through the governor for the release of the funds, after all of the calculations were done and we found out exactly who is eligible under the criteria, it was approximately, I don't have the exact number in front of me, but approximately 55 million for the compression and approximately another 12 to 13 million for 21 hours. We've asked for that to be released from the budget and finance, and governor did sign off and release that money to the department. I believe it was January of 23.
Okay, so in actuality, you received the original request for the compression, is that correct?
So out of the 121 million, there was sufficient funding for us to implement the compression adjustments.
Okay, but you originally said that you folks requested 55 million from BNF for the compression, correct?
That is correct. Yes, that was in our request through BNF to the governor for the release of those funds.
And you just said you were given the $55 million from the governor for the compression.
That
correct?
Is correct. Yes.
So were you involved in the SB 2819? That's the bill that I guess you I'm assuming DOE had asked the legislature to introduce. Is that correct?
To my understanding, I do not believe that DOE had asked the legislature to introduce this bill.
Oh, okay. Do you know who did?
I'm not sure who actually had it introduced. I believe the original bill was introduced by Senator Kidani, I believe.
Yeah, but I'm sure she didn't come up with all the information that was contained in it. So I'm sure somebody with all of the knowledge that I guess was imparted into this book must have either come from DOE or some other department.
Yeah, to my understanding, I do not believe it was DOE that requested for this bill to be introduced.
Okay, but then DOE did support it, right?
DOE did support it. So through testimony, we did support and provided information to the legislature through the legislative process through testimony.
Okay, and I guess how many actual teachers received this compression?
I'd have to look, but it's somewhere around the 9,000 range, I believe.
Okay, so I guess if you were to look at CU03, Exhibit CU03, that's the original Senate Bill 2018. I'm trying to get there myself.
Board Member White, is it 2018 or 2019?
I think it's 2018. It's CU Exhibit 3, CU03. Oh, here it is. It's
Okay.
map C-0016. Okay, Mr. Bacon, are you there? Do you have?
I'm
that?
on, yeah, I'm on C0016. I have the Senate Bill 2819 in front of me.
Okay, so I guess there's this little stamp up there that signifies when this bill was introduced, and it was introduced on January 21st, 2020. And then if you go down, okay, if you go to the second page, and there's little numbers on the left side that signifies a line number. If you go down to line 13, it states that 8,700 experienced senior teachers. Oh, this is to address, sorry, compensation equity issues, to make the necessary discretionary salary adjustments for approximately 8,700 experienced senior teachers. Do you see that amount?
I do.
Okay. So that's pretty close to what you just said of how many teachers were actually compensated in the compression fix, correct?
Correct.
Okay, so somehow somebody had already figured out in this bill that roughly 8,000 teachers would be receiving this compression. And the people who received the people who were given, I guess, credit for just BU5 service, is that correct?
Yes, so in the end, they were given credit for the compression adjustments just for bargaining unit 5 teaching experience.
So would it be safe to say then that in January of 2022, DOE had already contemplated of excluding outside BU5 teachers from the compression?
I'm not sure where this 8,700 number had come from. I mean, there was a general concept that was put together at that time, but the final details of it were not put together at that time until after the act was put into law, and then we had those final discussions with the HSTA. I know that this has been a long-standing issue of trying to address it, but I'm not. That discussion about including or excluding bargaining unit 5 experience was not finalized or talked about until after the bill was put into effect.
But how many teachers, by the way, does DOE have? Just, yeah, DOE teachers, not charter school teachers, DOE teachers.
It's approximately, it ranges a little bit, about 12,500, somewhere in that range.
I'm sorry, could you say that again?
Approximately 12,500. It varies a little bit, but it's somewhere in that range.
Okay, so if DOE or this bill was contemplating to give all the teachers a compression fix, then wouldn't they have said that in there about 12,000 teachers?
I think when, look at some of the data, even if you were to include or not to include the bargaining unit 5 experience, I mean, we do have several new teachers that start and have been with us less than 2 years. So some of that information or some of those teachers on average would not have been eligible for it, no matter if they had bargaining unit 5 experience or not.
And how many teachers would that be?
On average, the department hires approximately 1,500 teachers a year, approximately. So even if you were to take out the first 2 years of teachers, you would probably take out nearly 3,000 right off the top.
So you hire 3,000 teachers annually? Is that what you're saying? I thought you said you hire 1,500 teachers.
So for, in order to be eligible for the compression adjustments, 0 to 2 years of experience, you'd have to have at least the 2 years of experience to be able to get the step increase or, 1 step. So year 1, 0 to 1 year would be those first new hire teachers of 1,500. And then year 1 to year 2 would also be another 1,500. So in total, that would be approximately 3,000, give or take a few that probably would have not have been eligible for it, no matter if they had the bargaining unit 5 experience or not. It would have been those new teachers with no experience coming right to the department.
Okay, so if we minus 3,000 from a roughly 12,000 teachers that DOE has, then we're actually talking about 9,000. Is that correct?
Approximately, yes.
That would be eligible for the compression, correct?
Well, again, I think we had to really look and make those final determinations of eligibility and determine, what that criteria was.
Okay, and maybe I guess this bill maybe then would have addressed all of the teachers that would have been eligible for compression, including the outside BU5 teachers. Is that correct?
I'm not sure I understand your question, board member.
Okay, so you said there were about 12,000 teachers hired by DOE.
Correct. On average, that's approximately how many we have employed on an annual basis.
Okay, and then you said that you have to minus out 1,500 that are hired annually, and then another 1,500 that had only 1 year experience. Is that what you just said?
So on average, we hire approximately 1,500 new teachers on an annual basis.
Okay, and then you said that there's about 1,500 then that would have only had 1 year experience, correct?
They would have had 1 year of experience. Yes.
Okay, so is it my understanding when you're saying that 3,000 teachers would not be eligible for the compression fix?
I think what we have to look at is that, out of the 12,500 teachers, we had to look at a formula here and make determinations of who would be eligible, who would not be eligible, and it was determined that we were only going to be looking at bargaining unit 5 experience.
Okay, so you already, okay, so let me just make sure that I heard you right. So under this compression formula, people who are just hired, I guess it was that in 2022, was that the magic date that the compression formula started?
Yes, you had to be employed at the last day of 21 school year, and then at the start of the 2022 school year in order to be eligible.
Okay, so if you were hired in 2021, would you be eligible? That's the school year 2021. Would you be eligible?
So if you were hired in the 21 school year, and then you again were continuously hired and still hired in the 22 school year, you could have been eligible for compression, yes.
So if you were
But then
hired in 2022 school year, would you be eligible for the compression fix?
if you started during the 2022 school year and were not employed prior to that, then you would not have been eligible for a compression adjustment.
Okay, great. Thank you. That clarifies it. Okay, and let's see. Okay, so when did you say then that that DOE decided to exclude the outside BU5 teachers?
So the bill or the act was signed into law approximately June or July of 22. From June or July of 22 up until approximately September of 22, there was discussions with the HSTA to try to fine tune exactly all of the eligibility requirements, making sure we knew which teachers were going to be affected, which teachers we were not. That is when those discussions occurred between us and the HSTA.
Okay, discussions, I don't understand. I think Ms. Ashelman said that the only discussion that they had with you folks was to make sure that you weren't going to be changing the salary schedule. So again, what discussion? You keep bringing up discussions with HSTA.
Okay, so number one, we wanted to make sure that they wanted to make sure that the salary schedule was not going to be affected at all. So again, we were not going to change any of the dollar amounts in any of the different cells or each of the classes and steps on the salary schedule. So none of that was going to be affected. Questions did come up about who was bargaining unit 5 experience, non-bargaining unit 5 experience going to be considered or not. They had asked for it, but then we had further discussions with them. But in the end, both parties agreed that we were not going to include bargaining unit 5 experience as part of the calculation here. All of those discussions were made. We then, again, came up with final numbers. We've shared those numbers with Budget and Finance and Office of Collective Bargaining. And then eventually we asked for that money to be released. And in the meantime there, we also did a presentation to the Board of Education to inform them of what was going to be occurring from that point.
And when you said you had discussions with HSTA, are you talking about yourself in particular?
Yes, myself was involved in that. from our labor relations, negotiations, investigation section. I know Ananiole was involved, I believe, in some of those discussions. Our director from our recruitment section was also involved in some of those discussions with, I believe, Andrea from HSTA, along with possibly, I think it was Colleen Bird.
Okay, so when you just said that it was the HSTA, you had discussions with HSTA about the non-outside BU5 members, and that they had requested that the outside BU5 teachers would be included. Is that correct?
They asked us to consider it, yes.
Okay. And then you said that it was agreed to by the parties that you weren't going to include the outside BU5 members. Is that correct?
That is correct.
Okay. And that's you talking with HSTA?
Yes.
Okay. And was that including Andrea Eshelman?
Yes.
Okay. And do you have anything in writing that confirms that?
Don't know if I have anything in writing that confirms that, but I know that there was information that was posted, to my understanding, on the HSTA website informing members of who would be eligible. And then also it talked a little bit about the bargaining unit 5 and non-bargaining unit 5 experience.
Okay. But usually in an agreement situation between the employer and the union, it's always in writing. So I don't consider a newsletter as complying with a written agreement. So I take it then that there is no written agreement. Is that correct, Mr. Bacon?
Yeah, to my understanding, I don't think there's an actual signed written agreement from both sides on this, no.
Okay, thank you. Okay, getting back to the appropriations. Does DOE have any money left over from that 55 million that you've appropriated for the compression fix?
No, the entire amount has been used.
Okay, hold on. Sorry. Okay, I guess you've seen SB 2819. Is that correct?
Yes, that's
Okay.
correct.
I think in the original bill and actually subsequent drafts of that bill, there was a requirement for an MOU to be, I guess, executed or negotiated. Do you recall that?
I don't recall it about an MOU.
Yeah, hold on. Hold on first. Okay, so in CU, that same exhibit that I had asked you to look at, let's see. Okay, so on the third page, well, I guess it starts with section 2 on the previous page. Do you see section 2 on, let's see, that would be date stamp C-0017.
C017, which line are you referring to?
I'm referring to line 16.
Okay,
Okay, and okay, that's the beginning of section 2. Okay, and then if you read down to line 20, it starts with I guess 78-3.5 of a revised statute as negotiated between the superintendent of education and the exclusive representative of collective bargaining unit 5. Do you see that?
yes, I do.
Okay. Do you know why that was taken out in the last draft of the CD1?
I don't know why it was taken out. I know that originally, when this kind of was originally proposed, it was looking under experimental modernization project. But in the end, it did change to 89.9 F2. But I don't know why or when it actually had changed to that.
Okay. I guess are you responsible for the legislation and following it and so forth? Is that your responsibility?
So the way that the department does it is when bills are sent from the legislature over, our legislative team does assign it to different offices to review testimony and submit testimony to the legislature, yes. So for certain bills such as this, this would have been, reviewed by Office of Talent Management and then submitted to the legislature for testimony.
Okay, so you would then have been the lead on this legislation, is that correct?
Well, I would have been the lead to provide any testimony or go to the legislature to provide any testimony or answer any questions as the bill is making its way through the legislative process.
So
Excuse me, Board Member Moipono, can we take a short recess, 5 minutes?
okay.
We'll stand in recess for 5 minutes. Thank you. For 1 second, we'll go on the record. Let's go back on the record. Board Member Moipono.
Okay, thank you for bearing with me. It's been a while since I zoomed from home, so I still have to get back on the bike and be able to ride it, so to speak. Okay, Mr. Bacon, we left off with you being the, I guess it's the Assistant Deputy Superintendent for Talent Office, is that correct?
Assistant
Superintendent
for Talent Management.
Thank you. And that you were the lead on Senate Bill 2819. Is that correct?
So I was responsible from the department of providing testimony to the legislature as the bill progressed through the legislative session.
Okay. And I think we left off with that MOU that was originally in section 2 of the original bill 2819. And I had asked you, I guess, why that had been deleted in Senate Draft 1.
Yeah, and I'm unsure of why that was changed or deleted. I don't know why it was taken out of the final bill.
Would somebody in DOE know?
I don't know.
Okay. I guess then it'll have to, the only people that would have known would be Senator Kidani, and I think it was Representative Woodson, but since it was her bill, I guess, would she be the one that would know why?
I'm not sure if she would know either. I don't know.
Well, I hope somebody would know. Or, you know, these changes don't just happen, let me tell you. Out of thin air, people negotiate and, you know, come to some kind of agreement to have these provisions in or out, or so I would assume that someone like Senator Kidani would know the whole history of the bill, and especially since she introduced it, and she would be able to answer that question of why I think it was 88,700 teachers were named in the original bill. Do you agree?
She may know, yes, but I wouldn't be able to answer on her behalf.
Right. I don't expect you to answer on behalf. Thank you. Only on what you know. Thank you. Okay. Okay. This might have been a question that I had already asked, but so the money that was spent, the $55 million, was spent on roughly that 7,500 teachers that you had originally stated that were eligible for the compression fix. Is that correct?
That's yes, that's correct.
Okay. And those are teachers that sort of fit in your formula. Is that correct?
Correct.
Okay. So besides the ones who started in 2022, how many outside BU5 teachers that I guess, you know, had been there for over a year, how many of them were not included in the compression fix?
I don't have the exact data or the exact charts in front of me, but you know, again, overall, there's about 12 or 12,500 teachers that are all together in the department. I'd have to go and get the exact number of how many were actual eligible for compression. But basically, we would have just taken the overall total number and minus the ones that did get it, and that would give us the difference.
Okay, because I'm asking you for the difference, not how many necessarily got it, but the ones who were excluded. That was my question.
Yeah, I don't have the exact number in front of me of how many weren't eligible for it from that initial snapshot that we took from if they were employed in the end of the 21 school year and the start of the 22 school year.
Okay,
I'd have to pull that data.
Okay, are you talking about those charts that I think is in RE1? I think, but we can, maybe when we get to the DOE's case, you can look at those charts and then provide me with an answer then. Would that be all right? Okay. Got notes all over the place. Okay, actually, okay, that's it then. Thank you.
Thank you,
Thank
Board
you.
Member Moipono, Board Chair Oshiro.
Yeah, and Mr. Bacon, I just wanted to, is there a, I'm looking at the DOE E63. That's seems to be a memo from the Office of Talent Management, October 25, 2022. To all teachers from yourself. You know, it says interim assistant superintendent, but you're not the interim superintendent today, are you?
I'm no longer the interim.
You're the, you're the assistant superintendent.
That's correct.
When you sent this as the interim assistant superintendent, who was the superintendent? Or was there a superintendent at that time? Well,
I was the interim assistant superintendent for the Office of Talent Management. And then I report to the state superintendent.
who was the state superintendent?
I believe it was at that time Keith Hayashi.
So Mr. Hayashi is already there already. That Hishimoto had left.
Kishimoto had left, I believe, August of 22, I believe.
Okay, so Mr. Hayashi was the
I think he was interim superintendent at that time.
and interim designates that he has not been confirmed or appointed by the Board of Education.
That is correct.
So I'm looking at this memo, and it does describe the 2022 legislative session and the appropriation of the monies to the Department of Education per the Act 248. And the Act 248 we've been talking about is the appropriation for the compression fix, right?
That is correct.
And Act 248, do you recall if there was a bill that led to Act 248?
I think Act 248 was what was the department's budget that overall appropriated the money for the compression adjustments or the repricing adjustments.
And Act 248 is separate from Act 146 that you just went over with Board Member Moipono.
That's correct.
So I'm reading this, and it says the salary adjustments apply to teachers in bargaining unit 5 who are actively employed on the last teacher's workday of school year SY 2021-2022 with continued employment to the first teacher workday of school year 2022-2023. So I read that. So is that what you described earlier as far as who was eligible for the adjustment?
That was one of the eligibility criteria, yes.
Those would be maybe even the younger teachers who just started off with the DOE as a bargaining unit 5 member and maybe had up to, several years of experience.
Correct. As long as they were employed 21-22 and then the beginning of 22-23 school year, they met the first eligibility criteria. And then from there, we looked at how many years of bargaining unit 5 experience that they had to determine how many step increases we would be providing them.
Okay, so I kind of set the universe of eligible teachers. And then you looked at each individual teacher, whether they had at least 2 years of experience, right?
Yeah, so anywhere from 0 to 2 years of experience, they would not have received anything beyond the 2 years of experience. They would have received increases.
So the minimum number of experience with the DOE as a bargaining unit 5 member was 2 years. And if they had those 2 years, then you would give them a step increase.
Correct.
So a teacher could have entered the DOE bargaining unit 5 profession in school year 2019, let's say 2019,
Okay.
and work 2 years.
Okay.
Would that person be eligible after 2 years?
So if they would have started in 2019, they worked the full 2019-2020 school year and the full 2020-21 school year. I believe that under the formula we put together, they should have received, I believe, one step increase, as long as they were basically on a paid status for that entire 2-year period.
So it'll be safe to say that anyone who was employed and had met those requirements under this configuration prior to 2018 would be eligible. I mean, all things,
All things considered,
continuous employment and,
yeah, as long as they were on a paid status during that time and those types of things, yes, they should have been eligible.
okay. Okay, thank you. Okay, I'm gonna go back to what we discussed, I think yesterday with Mr. Reid and Mr. Take. So let's go look at HRS, Hawaii Revised Statutes 89-9. And do you have before you? Or? Okay.
Oh.
Yeah.
We have.
Thank you.
Let the record reflect that Mr. K did show a photocopy of 89-9 to Mr. Reid. Okay, so. Do you have it?
I do have it, yes.
Oh, okay. I'm gonna ask some questions on 89-9. It says scope of negotiations consultation. So there are two parts. The two relevant parts are 89-9F, right? It says the repricing of classes appropriate bargaining unit may be negotiated as follows. I just want to make sure we're on the same page at the same law. Okay, as follows. So there's part 1. It says at the request of the exclusive representative and at times allowed under the collective bargaining agreement, the employer shall negotiate the repricing of classes within the bargaining unit. You see that?
Yes, I do.
Okay, so again, I think if I heard the testimony from the HSTA representative and yourself, the 89-9F1 provision that I just read to you was not used in this repricing, right?
That is correct.
Question I have for you, did HSTA make a request under 89-9F Section 1 for the repricing?
I don't believe that they made a request under 89-9F1 to negotiate repricing.
Did they make any other requests or a request for repricing?
I think that the request that the HSTA had is we knew that we had teachers that were compressed and we had worked on an idea of how we could fix that compression adjustment. And I think that the 89-9F2 was one of the possibilities that could have been used to get to the intent of what we needed to do here.
Okay, and again, I think Board Member Whitepoint went over this, that the decision to proceed with the repricing solution was through the 89-9 F2 process provision.
Correct.
Okay, so let's set aside the 89-9 F1 provision. Oh, before we leave that, let me ask you this question. And if you can answer, I don't know if you're familiar with it, but it says in 89-9 F subsection 1, the negotiated repricing actions that constitute cost items shall be subject to the requirements in section 89-10. You familiar with that provision?
The provision of 89-10.
Yes.
Not off the top of my head, no.
So this last phrase that I read to you is negotiated repricing actions that constitute cost items shall be subject to the requirements in section 89-10. You couldn't explain that to me, that provision, right?
I'm not familiar with 89-10 off the top of my head, no.
Okay, let's move on to 89-9 F subsection 2. So it starts off, if repricing has not been negotiated under paragraph 1, the employer of each jurisdiction shall ensure establishment of procedures to periodically review, comma, at least once in 5 years, comma, unless otherwise agreed to by the parties, repricing of classes within the bargaining unit. See that, Mr. Bacon?
Yes, I do.
And I know that we went over it, well, Mr. Reid went over it a little yesterday. But I went back and I looked at the statute again, so I just kind of wanted to understand the subparts of those requirements. So it says the employer of each jurisdiction, is it correct to say that that would be the Department of Education as
Yes,
the employer?
yes,
And it says shall ensure establishment of procedures. So the question I think I would have, did the DOE establish procedures? And that's to do the periodic review of the repricing. As far as you know.
so I think typically it has been in the past, either a 2 or 4 year collective bargaining agreement. Typically at the time when employer and the union meet to do collective bargaining, wages and salaries have always been a topic of discussion. And I think that those are always things that we talk every time that we do go to the table about how we can, adjust the wages of teachers and how we can better have a qualified teacher in each classroom. So I feel that we do continuously do these reviews through the collective bargaining process.
So through the collective bargaining process, you believe that you would be compliant with this provision that says the employer of each jurisdiction shall ensure establishment of procedures to periodically review at least once in 5 years, repricing of classes. Is that a fair summary of?
Yes.
So is there any writing or memorialization of that process or the procedures?
There's nothing in writing or memorializing it, no.
But your testimony this morning would be that the periodic CBA and discussion of wages and salaries would include repricing.
Yes.
Yeah, I have another question here. I was reading through this and I was trying to understand. It says unless otherwise agreed to by the parties. So I would assume that would be the union and the employer.
Yes.
If there would be some kind of agreement regarding the periodic review once every 5 years, right?
Yeah, like I said, there's no written agreement between both parties on that, no.
Yeah, I'm just wondering because I'm seeing this term agreed to by the parties, and normally I think Board Member Waipona touched upon it. And when there's an agreement between the employer and the respective union, there's normally some documentation, some memorialization, whether it's MOU or MOA, but some way of demonstrating, the agreement between the parties. But you're telling me that there is none to your knowledge today.
I think, what the department has always typically done with the union when it comes time to renegotiate the contract is with the area of wages, working conditions and all of that are always topics that are brought up. And I think that that's always a time that we have an opportunity to review data, to review information and determine how we're going to best move forward with the negotiation process to ensure that we can compensate our teachers appropriately. So again, I think the goal always in mind is to ensure that we have a qualified teacher. I mean, the intent of the bill earlier was always about recruitment and retention. And I think that's always been a focus of both parties.
Okay. Then I'm gonna go to the next sentence, said the repricing of classes based on the results of the periodic review shall be at the discretion of the employer. So just looking at this provision of repricing, and again, I think we've heard testimony yesterday and also today that that's really at the sole discretion of the employer to proceed with repricing through 89.9 F2. That's the way you read it.
Yeah, it says it shall be at the discretion of the employer, yes.
So it would not need the assent or the agreement of the union.
It would not need the agreement of the union, but we've always collaboratively worked together with the union. We want to make sure that we were, treating our teachers, their members fairly through this process.
But it wouldn't be a subject of negotiation.
That is correct.
What about consultation?
We did consult through this process to make sure that both the employer and the union knew how this was going to be implemented. For them to ask questions, us to ask questions, and making sure that as we move forward through this process, both sides were knowing how we could communicate with our teachers, their members, on how this was going to be implemented.
Okay. And then the last sentence is any appropriations required to implement the repricing actions that are made at the employer's discretion shall not be construed as cost items. Mr. Baker, what's the significance of that? Not being construed as cost items.
I think what this means is that we would need to make sure that the employer had the funding in order to do this so that we didn't have to go back to the legislature to ask for funding to implement moving forward.
So it not being construed as cost items means that if the department has the funds available, that it would not need to seek an appropriation by the legislature.
Correct.
And just a couple more. So again, going back to 89.9 F1, the union did not request to negotiate on the matter of the repricing, right?
Yes, that is correct.
And do you have anything in your files or any recollection of any memorialization of that decision or that communication?
When I went to look through my files, I wasn't able to locate anything now.
And then, Mr. Baker, normally in your relationship with the exclusive representatives, when they communicate and they request or demand negotiation, what form is it made in?
It's typically made in writing where they're going to demand bargaining.
And that writing, would it be in an email or would it be in what I call snail mail or hard mail?
Yeah, to my recollection on this, there was no request put in by the union to demand negotiations for this process.
But if one had been made, it would be wouldn't be an email or text. It would be in some form like a letter.
It's typically a letter that comes from the union to the superintendent that usually is demanding some type of impact bargaining.
So because there was no request, there was no need for any response by the DOE.
Correct.
And likewise, no response necessary by the DOE in writing.
Correct.
Okay. Okay, I have no further questions. Thank you.
Thank you, Board Chair O'Shiro. Mr. Bacon, keeping the focus on section 89.9 of the Hawaii Revised Statutes. The first sentence that Board Chair O'Shiro touched upon, where it says the repricing of classes within an appropriate bargaining unit may be negotiated as follows, and then it has sections 1 and 2. Correct?
Correct.
Okay. And in this situation, the bargaining unit we're talking about is bargaining unit 5, right?
That is correct.
And there's a single individual class of members, which are all teachers, right, of bargaining unit 5.
Teachers, counselors, librarians, yes.
And were librarians and counselors part of this repricing?
Yes, all bargaining unit 5 members were.
And looking at F1 and 2, which you have in front of you, is there any authority in that statute when you're conducting repricing, either under subsection 1 or subsection 2, to exclude members of that particular class?
No, it says within that bargaining unit.
And so that would include all the members of bargaining unit 5, correct?
That is correct.
In this situation, though, and the reason why we're here is certain members of bargaining unit 5 were excluded from the reprice or compression fix through repricing, correct?
There was certain criteria that were used, but I mean, all teachers in bargaining unit 5 were considered, but there were certain criteria that needed to be met in order to meet these compression adjustments.
Right, and if that criteria that was established by the DOE, if they weren't met, they were excluded, right?
They did not meet the criteria, yes.
So they were excluded.
They not meeting the criteria, they were excluded, yes.
They didn't, okay, and they didn't participate in the compression fix, correct? Through this repricing.
So all classes within the salary schedule were considered, but we were also needing to consider bargaining unit 5 experience.
Okay, and that criteria for the bargaining unit 5 experience, that was done, that criteria was come up with, unilaterally implemented by the DOE, correct?
So in the end, the DOE did implement it after having consultation or discussions with the HSTA on how we were going to move forward with this adjustment.
Okay, and let me ask you, you have experience with consultations, is that true?
Yes,
And isn't it true in a consultation that agreement doesn't have to be reached among the parties?
that is correct.
And at the end of the day, if the employer proposes something and enters into consultation, even with an objection from the exclusive representative, the employer can go ahead and implement. Isn't that true?
That is true. I think we've always tried to work closely with our unions to ensure that we can work towards a mutual understanding as we move forward. But in the end, consultation does not require mutual agreement.
Okay. And when you do, and focusing more now on F2, when you conduct collective bargaining sessions that you referred to, are they a set of written established procedures that you have to follow in collective bargaining?
There are parts of the contract that talk about when the parties will meet and what timeframes, those types of things. Yes.
Okay. And within that collective bargaining framework, are there the establishment of procedures to address repricing?
It's not specifically mentioned in that, no.
Okay. So is there some other place outside of collective bargaining that there's a set of written established procedures that directly deal with repricing?
Not to my knowledge.
Okay. And so the bill, Act 146, I should say, was approved by the governor on June 27, 2020. So let's go back 5 years from then and say 2017. Was there a periodic review for repricing conducted by the DOE? If you know.
Well, the DOE does look at all classes of work, and we have made adjustments to different classes of work. We had recently made some repricing adjustments to school security attendance before. Years ago, we had made adjustments to educational assistants. And then even more recently, we've done some repricing adjustments for educational assistants. So the department does look at different classes of work when we do see that there may be a need to possibly consider repricing.
And in those instances that you just mentioned, were they established procedures in writing to make those determinations regarding repricing?
I think a lot of what has happened on those types of things is that the department has been approached by unions before in the past. We've talked about that there have been shortages, have not been able to fill positions. And we've looked into, those types of situations. And if something was warranted and funding was available, we were, willing to see what we could do to make those adjustments.
Well, let me ask you, if every 5 years, whether the union asks for it or not, does the DOE conduct a review for repricing? In your experience?
So I think, as I've stated earlier, I think, every time that the parties come to the collective bargaining table, topics do come up about, salaries and all of that. And I think that that's always been a topic of discussion when we do go to the bargaining table, which typically happens every 4 years.
If you look at F2, Mr. Bacon, does it say anything about having discussions with the exclusive representative?
No, it does not.
The responsibility, if you will, to conduct a periodic review every 5 years solely lies with the Department of Education in this situation. Isn't that true?
Yes.
Now, I apologize for jumping around, but if we can go back to C64, it's Act 146. Let me know when there's that. Okay. And I'm not going to read the whole thing, but in that section 1, the act basically discusses the chronic teacher shortage and regarding recruiting and retaining qualified educators and how the salaries in Hawaii are generally lower than most other jurisdictions in the country. Would that be fair?
Correct. I think when you consider cost of living, Hawaii is low.
And if you continue on to the second page, the act discusses repeal of sections 302A-624C and 32A-627A of the Hawaii Revised Statutes, correct?
Yes.
Okay. And then they amended 302A-624, correct? You see that on the
Is that on line?
section 2, where it says section 302A-624 Hawaii Revised Statutes is amended to read as follows.
Yes, I see that.
And then when you look at the amendment, it has the different requirements for teachers and how they get credit, or in subsections B1, 2, 3, and 4.
Okay.
Right?
Yes.
Um, is there any mention there in that section about the initial credit granted to teachers of the 6 years of experience outside of the DOE, that can be excluded?
Can you repeat your questions?
Sure.
Yeah.
In B1, 2, 3, or 4, is there any mention that the 6-year credit for non-bargaining unit 5 experience can be excluded?
It does not mention anything about that.
In fact, if you look at subsection 4, it actually refers to other credits approved by the department. You see that?
I see that, yes.
And that 6 years that's granted to certain teachers, that's a credit that's approved by the department, correct?
So these,
Up to 6 years.
so these credits that I believe they're talking about here would be, I think, used possibly for teacher reclassification from one class to another class.
Oh, Mr. Bacon doesn't say that. Is that what that subsection 4 says? Doesn't it say other credits approved by the department?
Or other, yes.
And then if you go to C68,
Okay.
they amended the section regarding credit for military service, right?
They amended the section that was amended was salary ratings for entering or re-entering teachers. That's what was amended.
But now the section now just read credit for military service, right?
So on line 8, it says credit for military service, and then it picks up again on line 17.
Correct. And in this section, again, there's no mention of the exclusion or anything of the up to 6 years credit that can be given for non-bargaining unit 5 experience. Is that true?
Yeah, it does not mention anything about the 6 years here.
Okay, if we can go to the employer's exhibit 8, E8. This is the presentation by Superintendent Hayashi, I believe, to the Board of Education. Let me know when you're there.
Okay,
And this is dated October 6, 2022, correct?
that's correct.
So by this time, you'd already had the funds appropriated by the legislature.
That is correct.
In your experience with the DOE, have you ever had another situation where the funds were appropriated first prior to having an agreement in place?
That was the first that I was aware of it, yes.
And under Mr. Hayashi's executive summary, there's some bullet points there, if you see that on the first page. And if you look at the first bullet point, right, it just talks about the compression, teacher salaries, veteran teachers, and so forth, correct?
Correct.
And in the last bullet point, the plan provides employer-initiated pay adjustments based on years of service in bargaining unit 5, BU5, right?
Correct.
Okay. And so that implementation, again, that was a decision made by the Department of Education, correct?
Correct.
You didn't need, even if you had it, you wouldn't need HSTA's concurrence or agreement to implement that. Isn't that true?
Correct.
Now, if you go to E9, and it's under the presentation, and you may not know this, and but we'll go through a variety of numbers here, because in the first paragraph, you look about halfway through, it says that current data shows that more than 5,432 teachers between 0 and 24 years of service are clustered between steps 9 and 30. And then are more than 2 steps below where they would be if there were regular step movements. You see that?
I see that, yes.
Okay. And that would be data that Mr. Hayashi got from the Department of Education?
Yes, so we pulled data from our system to start to filter through this information.
Okay. And so at least at that section, we're not talking about 8,700 or 9,000 some plus teachers. It's 5,432, correct?
Well, that's what, yes, so 5,432. We saw a very large clustering within a certain area of the salary schedule where people were concentrated. That didn't include everybody, but we just saw a large clustering in a certain area.
Okay. And then if you go to the third paragraph, it says pursuant to Hawaii Revised Statutes HRS 899, the department has consulted with the Hawaii State Teachers Association to draft the implementation plan. And that both the State of Hawaii Department of Human Resources Development Office of Collective Bargaining and the State of Hawaii Department of Budget and Finance have been consulted on the implementation plan. And so both of those situations were true consultations under 89.9, correct?
Yes, we did consult with the parties to ensure that they understood what was going to be implemented and how we were going to be moving forward with the process.
Okay, but again, HSTA's concurrence or agreement or the agreement of the Office of Collective Bargaining or Budget and Finance is not necessary.
In the end, under 89.9, it was not necessary.
And then the next paragraph is where we get that the salary adjustments are going to apply to approximately 9,196 teachers
Correct.
who are actively employed on the last teacher workday of the school year 2021-2022 and continued employment on the first teacher workday of the school year 2022-2023. You see that?
Yes.
Does that statement mention anything about exclusion of any kind of service? Or does it simply say, if you worked on the last day of the 2022 school year and started up the next school year, the adjustments would apply to you?
It states that if you were employed on the last day of 21-22 and the first day of 22-23, that there were 9,196 teachers that were eligible.
And just for your recollection, if you look at the last paragraph, I think that's the number you were referring to.
That's
Of the
55 million.
estimation of the cost of this.
Yes.
Now, if you go to E16, this is part of the Hawaii State Department of Education, the implementation plan for salary adjustments. And there's no, even though it's referring to the 2022-2023 school year, there's no date on this document, or was it, if you know, was it attached to the presentation given to the Board of Education?
This was our attachment to the presentation to the board.
Okay, so this is in October 6th, 2022.
Yes, that's correct.
Okay.
In exhibit E10, it does say attachments A, B, and C on there, and this was one of those attachments.
Okay. And so if you look again at the first paragraph, and I'm not trying to be nitpicking over this, but I believe it's an important issue. In the second sentence, it says, for many veteran teachers, salary was not commensurate with teaching experience and years of service, right?
Okay.
And so, again, there's no mention of any kind of exclusion from people from the class, at least at this point, right?
It doesn't say about any exclusion at this point, no.
And if you look at the last paragraph in the executive summary, it says in the school year 2022 to 2023, the department will implement a pay adjustment for existing teachers with a salary that is less than or equal to that of less experienced teachers in comparable or similarly situated teaching positions, correct?
Yes.
Okay. Again, there's no mention of any type of exclusion of members from that class.
It doesn't talk about exclusion.
If you go to E19, the implementation summary, the first paragraph, does that mention anything about exclusion or limiting qualification to bargaining unit 5 experience?
It just says the salary adjustments will apply to approximately 9,608 teachers.
Oh,
who are
I'm
in
looking at the first paragraph on page 19.
Department will be implementing a pay adjustment, that paragraph.
Yeah.
To the salary of existing teachers commensurate with their years of service to address teacher. Yes, it does not mention any exclusion.
And then under the general applicability in the first paragraph, it's pretty similar to what we've read before. That you were working on the last day of the 2021-2022 school year, and continued employment on the first teacher work day of school year 2022-2023.
That's correct.
So here we talk about the 9,000, or this document talks about the 9,608 teachers, correct?
Yes.
Okay, then you go down to section 3, approximate costs associated with the implementation. And if you look at the first paragraph, it says of the department's total of 12,741 teachers, this plan will affect approximately 72% of the workforce. This will positively impact approximately 9,196 teachers who meet the criteria to receive the one-time salary adjustment. You know why there's about a 500 teacher difference between the numbers under general applicability and then the approximate costs?
Great question. I would have to look into that. I don't know.
And again, just so it's clear, I don't mean to keep harping on it, but you know, we are applying the law. Under F2, when you're going to reprice a class, and we've already established that all of these teachers are part of the same class, what is the authority for the DOE to decide repricing that it's only going to apply to 72% of the teachers and not 100% of the teachers? What is the legal authority for that?
I think 100% of the teachers that were in the classes that were on the bargaining unit schedule was the initial criteria. And then from there, we looked at to determine if they were employed between the 21 and 22 school year. And then from there, what we were looking at to meet the intent of what we were trying to do is look at making sure that bargaining unit 5 experience, which we had jurisdiction or control over as the employer, we wanted to make sure that we could meet the intent of that compression of where we saw a majority of our individuals or teachers were compressed at. We wanted to meet the intent to try to decompress them so that we could give them the steps that they didn't receive when they were employed at an earlier date.
My question goes more to under F2, which you should have in front of you, or 89.9F, the whole thing. Either in that section or any other statutory section, when you're repricing a class of employees, what authority exists to allow the DOE to determine some implementation that's going to exclude people from that class from receiving the benefit of repricing?
I think what the DOE was looking at is bargaining unit 5 experience. And I think that was part of our
Mr. Big, I
criteria.
must stop you right there.
Okay.
Okay. My question is, what is the legal authority, whether statutory, a Hawaii administrative rule, whatever there is, that when the Department of Education conducts a repricing of a class, that it can exclude members from that class from receiving the benefit of repricing? If you know of it.
I'm not aware.
Thank you, Mr. Durkin. I would nothing further. Mr. Reid, do you have any questions based upon the board's questions?
No questions.
Mr. Takei, you're gonna reserve?
No, if I may, can I ask?
Sure.
Follow-up questions
Sure.
based on, Mr. Bacon, can you turn to E8 at the top? Okay. Um. Now this goes to something that uh board member Morkono was asking. I believe he asked what time period of salary compression was DOE concerned about. And you know, if I'm accurate, I think you said one of the time periods was 2008 through 2018. Was that, is that correct? Is that what you said, or?
Yeah, I think between 2008 and 2018 is where we saw a large number of teachers in this conglomerate, basically. But
Okay, I'm sorry, that wasn't my, I don't mean to stop you, but I was just asking, what was that? Is that what you said? That was an area, that was a time period that you were
a large area,
concerned about?
a large area were in that 2008 to 2018 period.
Okay, so in E8, executive summary, you know, the first bullet point. Could you read that out loud? I mean, it's pretty short, just 3 lines, the first bullet point.
The lack of step movements for teachers in the past has resulted in the compression of teacher salaries and veteran teachers not being compensated for the years of service in the classroom.
So the part where it says the lack of step movement for teachers in the past, does that mean just the 2008 through 2018 that you were saying that DOE was concerned about salary compressions?
It didn't limit it just to the 2008 to the 2018. That's where we saw a large majority of them, but it also allowed for teachers that prior to that time period also and after.
Okay. But would it be fair to say that salary compression is, or as to this bullet point, they're talking about lack of step movements in any year in the past for this particular bullet point?
That would be accurate, yes.
Not a specific time period.
Correct.
Okay. Now, my apologies, board, if you can bear with me. I'm
Nope, take your time.
I'm looking for 248 and I got where who had it. Oh. Okay, can you go to at the top, it's U19.
Okay.
Okay, so I want to, can I turn your attention to the line 10. It says, well, 9, sorry, from 8 to 10. It says the sum of 121 million some odd dollars or so, much thereof as may be necessary for fiscal year 2022 through 2023 shall be expended for repricing. What does that mean to you?
So this gave the department the authority to spend this money to do repricing of our teachers pursuant to Chapter 89.
Okay, so would it be fair to say if you wanted to use that money, you had to use it for repricing? Or, you know, and other cost items pursuant to Chapter 89?
Yes.
You had to use it for repricing or the rest of the sentence?
Correct.
Okay. So if you used it or if you came up with EMP, what is your opinion on whether or not you met this legislative intent?
I think EMP is not pursuant to chapter 89, so I don't think we would have been able to use this funding for that. We only were able to use it for repricing pursuant to chapter 89.
Okay. So it wouldn't have been at your discretion to use EMP, which is off the top of my head, I think, well, a different chapter that's not chapter 89.
Correct.
Now, in this section, does the board, does the legislature include instructions on how repricing is to be accomplished?
No,
Did the legislature require a plan to be created?
not to my knowledge. There was nothing in the act.
Is there a, well, let me start. Back up. Is there anything else that the DOE, were there any other instructions by the legislature to the DOE that's not contained in this particular section of the Act 248?
Not to my knowledge.
Okay, so your understanding of what to do with that money is within the scope of what's written here? That's what you're saying?
That's correct.
And I'm sorry, did I ask whether it was DOE's understanding that the ledge required negotiation?
There was nothing in here that indicated that negotiation was required.
Okay, and what about any requirement from the ledge that once the repricing plan was finalized, to come back to the legislature to have it approved?
There was nothing that I'm aware of, no.
Okay, so would it be fair to say that the legislature completely left it up to the DOE to determine how it was going to implement repricing?
I believe so, yes.
Now, okay, so did DOE elect to use 89.9 F2 as its authorizing vehicle to implement repricing?
In the end, that is the authority that we used, yes.
Okay, and earlier the board was asking, starting with the first sentence, right next to F, it says the repricing of classes within an appropriate bargaining unit may be negotiated as follows. Did I read that correct?
Yes.
Okay. Can I turn your attention to the terms within an appropriate bargaining unit? Does that mean to you that is the repricing of classes of the entire bargaining unit?
Yes, it's the entire bargaining unit, all of the classes that are on the salary schedule.
Well, I guess my question is, that's what the plan, DOE's repricing plan did, right? If it was applied to the entire class, is that what you're saying?
It applied to,
I'm sorry, go ahead. Please answer.
Yeah. So all of the classes on the bargaining unit schedule were taken into consideration, yes.
Okay, but back to my, what I was trying to ask, I probably worded it poorly. If it said. There's a difference between within a bargaining unit and the entire bargaining unit. Would you agree?
The repricing of classes within an appropriate bargaining unit may be negotiated as follows. So we looked within that bargaining unit at the classes to reprice.
There's no requirement by that line that requires every teacher in the bargaining unit to be considered for repricing. Is there?
Not that I see, no.
In F2, is there any instructions on how to implement repricing?
No, there's no instructions.
I know, the board asked. The board asked, is there any authorization in F2 that authorizes exclusion of teachers? Do you remember the board asking you that?
Yes.
What about the opposite? Is there anything in here that says that teachers cannot be excluded in repricing?
It doesn't say that, no.
Okay. So does this F2 just refer to, what is your understanding of F2? Why is it there? What is it saying? Okay. Let me more target my question. I'm sorry. Is it your understanding that F2 sets out when the employer can use its discretion to implement repricing? Under what circumstances?
Yes, this authorizes the employer or of the jurisdiction to do repricing.
Okay, thank you for the clarification. That's all the questions I have.
Thank you, Mr. Takei. Mr. Alapa, any questions?
Yeah, just a couple. Mr. Bacon, you, in response to questions from the board, you talked about BU experience. Do you remember that?
Yes,
When you talk about BU experience, that was the ultimate criteria that the employer relied on in implementing its compression adjustments.
that is correct.
And when you say BU experience, does it matter whether the non-BU experience occurred on the mainland or in the state of Hawaii or on another island? Did that matter?
No,
Can BU experience pertain to experience gained with the DOE?
the DOE or charter school, yes.
Charter schools?
Yes, covered
And-
under HSTA's collective bargaining agreement.
And on the other side of that line, non-BU experience, did it matter where that non-BU experience occurred?
No,
Did it matter if the teacher was black, white, brown?
no,
Experience, where they received the experience was that line in the sand.
yes.
Let me get some clarification. Was it a little confused on the number of teachers that were affected by the compression adjustment or fix? You answered questions from Board Member Moipono regarding SB 2819, which is CU 03, and in particular, base stamp on the top right, C0017. Number listed there is 8,700 experienced senior teachers. You remember that?
Yes,
This, correct me if I'm wrong, this applied to the EMP proposal that occurred before the repricing proposal. Is that correct?
that is correct.
Okay, then in response to questions from regarding the implementation plan for salary adjustments, which is RE1, do you recall? Questions from Board Member Moniz regarding that document.
Yes,
And in that document, the number increased from either 9,100 or 9,600 teachers. Is that correct?
that is correct.
Okay, and so at some point, someone within your department made the decision to switch the vehicle used for the compression fix from the EMP to repricing, yes?
Eventually changed to that, yes.
Okay, and that was a decision made by someone within your department.
Again, I don't know when that decision was made to move it from EMP to 899 F2, but yes, in the end, we ended up using F2 as the authority.
Okay, and in making that switch, it appears based on those documents, more teachers actually receive the benefit from the compression adjustment or fix because of that switch based on these numbers.
Yes, so the number in the original bill did increase from 8,700 to approximately over 9,000, yes.
And this implementation plan, document RE1 starting at E0014, that was provided to the union, correct?
E00104. Yes,
And on page E0020, the big stamp at the top right, it's noted there that the department has consulted with the HSTA and will continue to do so until the final implementation. The department and HSTA have agreed to negotiate any modifications of waiver or salary adjustments. Yes?
yes,
Okay, and that was put into writing and provided to the union.
that is correct.
And the employer did continue to consult with the union until the final implementation.
Correct.
Okay, that's all I have.
Thank you. Mr. Lapa, Mr. Reid, anything further?
Just two questions. Were the numbers just referenced a moment ago, were those exact figures or estimates?
At the time that those numbers were pulled, those were exact numbers, the numbers can change on a day-to-day basis if somebody were to separate and those types of things. So at that time, those were an exact number.
The discrepancy of about 500 teachers, was it your testimony prior that you didn't know why those numbers were different?
Yeah, I indicated to the board, that was a good question. I would have to look to see why there was just that discrepancy there. I don't know.
So do you have any reason to believe that the change from the EMP to repricing created that change?
I'm not sure if that made a difference on that change or not, but I think after our final decision to use 899 F2, after consulting with the HSTA on some of the implementation plan, that was eventually our final plan with some of our final numbers.
And is it your testimony that those final numbers were better under repricing than under an EMP?
Well, the numbers that were originally presented to the legislature under EMP compared to the numbers that were the final numbers, the numbers did show a slight.
So is it your testimony that the repricing was more inclusive than the EMP?
What I'm saying is that the original numbers to the final numbers did include more people in it.
So the original numbers were an estimate, correct?
They were an estimate, yes.
And the final numbers were an estimate, correct?
Well, the final numbers that I think were put in there were based on a snapshot at that time period. And like I had said, the numbers can change depending on if people may leave the department or not. So, I mean, it could alter slightly.
Was the formula for steps, I'm sorry, for years of service to steps different under the EMP proposal than the requested proposal?
My understanding is I think it was this type of formula.
Okay. No more questions.
Mr. Takei, anything based upon Mr. Reid's question?
No questions.
Mr. Alapa?
No, thank you.
Board Member Moipono, do you have any additional questions?
Yeah, I just have a couple of just based on questions that you had posed. Mr. Bacon, I think I just wanted to ask you, are there any rules in the standards of practice or the Hawaii administrative rules that implement HRS 89-9F2?
Not to my knowledge.
Okay, thank you.
Board Chair O'Shea?
Yeah, Mr. Bacon, prior to the employer using its discretion to reprice per Act 89-9F2, when was the last time the employer used that provision? If you can recall.
I don't know.
And so during your time at the DOE, you don't, I mean, as an administrator, you don't recall.
During my time as assistant superintendent or interim assistant superintendent, I don't recall anything occurring during that time period. No.
And when did you hold those positions? From what one was that?
So I originally became the interim assistant superintendent in May of 21, and then was officially confirmed by the board in December of 22.
Okay. So to your knowledge, pursuant to Act 248 and allowing the DOE to follow Chapter 89 and effectuate the repricing, that was your first experience with Act 89-9F2.
That was my first experience, yes.
I think you also stated in your testimony that the appropriation that was given from the legislature was unusual because it was made prior to any contract settlement or finalization of any contract term or condition.
Yes, that's the first that I had seen where the appropriation was given before, yes.
Well, then one thing I think Mr. Alapa asked the question. There is a provision that stated that the department and the teachers have agreed to negotiate any modification or waiver of the salary adjustment. Is that correct?
Yes,
And was that reduced to some form of writing?
I would have to check. I'm not sure if it was put in some type of writing. But I think it was put in writing when we presented it to the Board of Education.
Okay, thank you. Thank you, Chair.
Mr. Bacon, I just have one question, just to clear it up. You may have answered it already, but when the DOE was having its consultation with HSTA, do you recall if HSTA specifically requested that the up to 6 years experience be included as part of this compression fix?
Do I recall if they requested that the 6 years be included?
Yes.
Yes, so during our consultation or during our discussions, it was asked and it was talked about from the HSTA if, you know, it would be something that the department would consider using.
Thank you. I have nothing further. Any other, Mr. Reid, anything further?
Nothing further.
Okay.
No
Okay,
questions.
Mr. Bacon, thank you very much. You're excused.
Thank you.
Oh, yeah, I think that's actually, thank you, like, thank you, thank you.
I appreciate it.
Okay, Mr. Reid, who's your next witness?
We have no more witnesses.
Okay, Miss, I just want to make certain that, you know, Ms. Campbell, Ms. Best, you know, you as parties, you have the right to testify. So I want you to understand.
We would like to call Ms. Donna Campbell.
Ms. Campbell? Ms. Campbell, do you solemnly affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing?
I do, yes.
Can you please state and spell your first and last name for the record?
Donna Campbell, Donna, Campbell, Campbell.
Okay, thank you. Mr. Reid, are you going to be questioning Ms. Campbell?
No, she's gonna give testimony.
He's been a spokesman up to this point.
Yeah.
Can we just go back to the regular procedure? It makes it much easier for us.
Yeah, Mr. Reid, you represented that you're representative of all the parties, so
Would you like me?
no, hold on. So in that capacity, you should be the one asking questions of Ms. Campbell. Yes, Mr. Dick.
I apologize for it. This is unrelated, but can I have a short recess? I just want to make sure that he didn't think Mr. Bacon didn't think he could leave.
Absolutely, go ahead. Yeah, we'll take a short recess.
We're rolling.
Back on the record. Ms. Campbell, even though I just read it to you, I have to remind you again that you're still under oath.
Yes.
Mr. Reid, can you proceed?
Yes. What is your understanding of compression and how it applies to you?
Okay, so I've been employed with the DOE since 2010, and I've worked through till 2023, or I'm continuing to be at the Department of Education. When compression first was announced, or when HSTA provided information about compression, I questioned it because I noticed that they did not include my previous DOE service or my accredited service. So immediately I contacted the offices of talent management, and I inquired as to why my years were not included. And I was told by the offices of talent management that there was a no appeal to compression. Therefore, I was referred to the October 6th memo, which indicated October 6th, 2022, which would give me an explanation as to what compression was. So I would like everybody, actually, if we can look to the October 6th, 2022 memo. And that would be RE1.
Section.
Find it.
Okay.
Can you give us a page number?
Actually, I'm looking for it.
It's the third section. There are three dividers. It's the third of the papers.
Third one. Here's our one.
RT. I'm sorry, RT1.
RT1.
Sorry, second section, second section.
Second section.
Yeah, sorry.
You're,
Yeah. Second. No,
it's like they are the same.
Sorry, I don't think I have it here, Mr.
E8 at the top.
E8. Thank you very much. Okay. So in reading through this and seeing the salaries, I question because I've been working for the Department of Education for 12 years. At that time, I was employed by the department. I had worked for the private school sector for approximately 10, 12 years. And when I went to the Department of Education, I was told that I would be given a maximum of 6 years. I had one previous year at the DOE, so I actually started on step 7. I worked from 2010 through to the compression period of time of 2022, which would have been another additional 12 years. So 12 years plus 6. I was told that I would remain on step 11 because I was told by the Department of Education, Talent Management, that I would remain on that because the compression does not include my previous salary experience. So looking through the October memo, I'd like everybody to take a look at, sorry, just one section. The methodology.
What page is that?
And I will give you just one. Okay, E0018. Would I be able to have demonstrate this on a plain piece of white paper? Is that okay? Just for clarification for those who are, or would you like, I can discuss it, but if you'd like, I can also show it to you.
She's a visual teacher.
I'm a visual teacher. I teach SPED. So in order for everyone to clearly understand what I'm saying, but it's up to you. If you don't want me to have the piece of white paper, it's up to you.
Mr. Takea, you have any objection?
Yes, I object.
Okay. That's
The writing is not part of the exhibits, and it's difficult to understand handwriting through the videos or.
Okay. That's okay. I'll do it verbally and I'll try to be as simple as possible. So if you look at the methodology that they talk about, the Department of Education talks about years of experience, and they give an example, second paragraph down. If the same individual gains non-department teaching experience while not in service, a maximum of up to 6 years of non-department teaching experience will be added to the amount of previous teaching experience within the department. Therefore, if a teacher who left service with 10 years of credible service time re-entered service after gaining 10 years of non-department teaching experience, the teacher will have 16 years of teaching experience recognized for salary step placement, 10 years with the department and 6 years credited for non-department experience, and will be placed in the same step as an incumbent teacher with 16 years of teaching experience. So that is the methodology of the Department of Education. Let me make it simple. I will round it down because I believe Miss Best is closer to those numbers. So Miss Best was given 6 years of credited service. She works an additional 10 years. With compression, she has 10 because her 6 years are not counted. If you look at the methodology of how compression will be implemented and you reverse the equation, the Department of Education is actually saying, if you work 10 years in the Department of Education, you leave You come back, we'll give you 6 years for a total of 16. The picture I wanted you to see was 10 plus 6 for teachers today equals 10. A teacher returning to the Department of Education is going to be placed on step 14 while Miss Best remains at step.
Objection, Ms. Campbell is misstating how the repricing methodology works. Mr. Bacon made it clear that in.
Go ahead, Mr. Tickett.
Oh.
Oh, that's, go ahead. I didn't mean to interrupt.
Okay, Mr. Bacon made it clear that in order to be eligible for repricing, a teacher has to be between 2021, at the end of school year 2021, I believe, and being still active at the beginning of school year 2022. A new teacher that comes in now would not be eligible for repricing. So you know, a teacher cannot go outside, get 6 years, come back, and then now be at least applied to use this particular repricing implementation methodology that was a one-time implementation. I can't speak to what placement a new teacher would be at now, but I can be certain that this implementation would not apply to a teacher that just came back, if that is what Ms. Campbell is setting out as a hypothetical.
Hold on, Ms. Campbell. I'm gonna overrule the objection because she is just testifying as to her interpretation of this section. And I must say, Mr. Takei, your description of what the testimony should be or is, I just take that as part of your objection. And this is just Ms. Campbell's interpretation of what she's reading.
Thank you.
Continue, Ms. Campbell.
This was the section, this was the memo that I was referred to by the offices of the Department of Education. I sent 2 emails. First, one email to the personnel office, and then I was referred to the department, the personnel of talent management. Both told me there was no appeal process for compression and that they should refer me to the memo. In reading the memo and looking through the memo and seeing how repricing was developed, they give a clear example of how they're going to place people. If I look at, as I said, Miss Best, because I'm in exactly the same position, however, we're talking 12 years and it's confusing with the steps. So that's why I'm referring to Miss Best's situation. So as I said before, if you have 10 years of experience, if you were currently employed with the Department of Education, and I think Miss Best, you started in 2010, and so working right through. So 10 years, 6 years granted when you first started working, and you accumulated an additional 10 years. Repricing gave you nothing. It gave you your 10 years. You lost your 6 years. However, a teacher, which is clearly written here by the Department of Education, coming in now, this is how they're going to, this is their methodology that they wrote themselves. They said that a teacher returning who originally had 10 years, accumulated 10 outside, they would be credited 6. Therefore, they would be placed 3 steps higher than a current teacher. So I really think that it's important that the board understand that repricing and the discrimination is only towards one small group of teachers. The benefit is retained going forward. The Department of Education grants 6 years of experience of credited service. Anybody coming in gets that credit. But anybody who was in between, in other words, if you were not a new teacher, and if you had that experience and repricing occurred during repricing, we were the only group, we were the one group who lost that experience because that experience is now given back as we go forward. I'd also like to address the word initial place.
Hold on, Ms.
Objection, and I'm allowing the narrative to go, but if we can get back to the questioning so we can understand where we're moving to, because it sounds like we're moving to a different area.
Okay,
Mr. Reid.
What is your understanding of the initial placement policy?
initial placement policy. So when I applied to the Department of Education, I had worked for some large private schools and I had experience. I was told by the department that I would be, that my experience would be recognized up to 6 years. So I then started at the same level as a teacher who had 7 years experience and continued during those compressed years, gaining an additional 12 years of experience. Therefore, I have 12 plus 6. And so I am at the same level as a teacher who has 12 years experience. So my 6 years are gone. The word initial, I have not found it in the CBA. Please correct me if I'm wrong. I believe that it has been used a number of times in my pretrial, March 7th, 2023. It's been used a number of times by the Department of Education in describing how I should be placed, but the word initial is not in the CBA. And I believe the CBA is a carefully crafted document in which every single word is reviewed. And therefore, I don't understand why it has been interjected for us to believe that it is part of our contract when we signed the initial contract.
Excuse me. What is your understanding of your lost wages and other financial implications to having your 6 years excluded from repricing?
Aside from the fact that I have lost $7,397 each year because I did not reprice with my colleagues or with people who had the same experience as myself. So the loss of $7,000 is one thing, although I've probably lost more in the number of days that I've taken without pay to come to this trial. The fact of the matter is, I went into the Hawaii retirement system and I put those $7,000 into my retirement calculation because they do have a wonderful little calculator for those of us who are getting near retirement. And I just was curious as to what $7,397 odd would reflect. And if we've already been 2 years into the lost wages, if I go one more year and those will be my top 3 years, that $7,000 reflects into a loss of $200 per year for the rest of my life. That is just in my retirement for the ERS. That does not reflect Social Security and the changes in that. So therefore, I'm at a loss not only for the $7,000 per year, I'm also at a loss for my retirement. I'm also at a loss for my Social Security. So therefore, it's not just a one-time thing where I've lost wages. And I have colleagues who at school, when we discussed the wages, there was definitely a feeling of relative deprivation because I'm an experienced teacher. I gave up a career at another school to work for the Department of Education. And I came to the Department of Education who desperately need experienced teachers. And I'm happy to work there. However, I was not happy to lose that, not only money, but respect in them not valuing the fact that I had made that sacrifice to come and serve with the Department of Education.
No further questions.
Thank you, Mr. Reid. Mr. Takei?
Ms. Campbell is also on my list later on, so no questions at this time.
Thank you, Mr. Olapa.
Yeah, just a couple of questions. Ms. Campbell, you referenced the word initial. Do you remember that?
Yes.
And do you recall that you used the word initial in your complaint related to this case?
If you could read it to me.
Sure. On page, it's not numbered, but the first page of the narrative attached to the form, subsection 5(2), you state, Article 10 describes two rights, benefits, and privileges of employment. One, the status of being equal to an incumbent teacher with service equal to my prior experience up to 6 years. And two, the specific steps granted upon initial hire are an additional right, benefit, and privilege of employment. Do you remember writing that?
I remember writing it.
And under part 6, in reference to the school code, you can see that it discusses the initial placement in the salary schedule. Do you remember putting that into your complaint?
I don't remember the second part, but I did reference, because initial, when anybody is hired, they are initial hire. So they start out, the word initial means
So,
begin.
Stop, I'm just asking, you asked for references where the word initial
Yes.
was used, and I'm just pointing that out
Sure.
to you. And are you aware on the salary schedule itself on the CBA, the word uses initial classification? Were you aware of that?
And it's, but that's not in reference to the salary. That's not in reference.
Are you aware of that? That's all I'm asking.
Oh, I wasn't aware of it.
And subsection I, under Article 10, which is the citation, those articles cited by the complainants, it states new hired teachers entering the salary schedule. Do you remember that wording at least?
Yes.
And the plan that you cited to with the example, you recall that was E0018. On the page before that, one of the examples is initially entering the department service. Do you recall that?
Correct.
Yeah, that's all I have.
Thank you.
Thank you, Mr. Olapa. Mr. Reid?
Yes, and I don't have a copy of the board exhibit of the contract. Can I get a hard copy of the contract? Do we have one available?
I have one.
Can I use it?
Thank you, Mr. Takei.
Article 20. And Article 20 is entitled salaries. And round 70 article. I'm going to read section E, and I want you to stop me when you hear the word initial.
Objection. So we all can read it. I never represented that it said initial. I said new hired teachers entering the salary schedule. That's all I said. This is just a reading exercise, not appropriate.
Mr. Reid, do you have a question about that section?
Does the word initial appear in section E of Article 20?
No, it does not.
Okay. Is Article 20, section E, the focal point of this hearing?
It is.
And just to be clear, the word initial does not appear in section E of Article 20?
No, it does not.
Does it indeed say that those, according to Article, is there interpretation, is it your understanding that Article 20, Section 8 states that you are to be placed in the same step as an incumbent teacher with equivalent years of experience.
Yes, that is my understanding. And it was my understanding in 2010.
That's all.
Thank you, Mr. Reid. Mr. Takei,
No question.
Mr. Alapa.
Real quick, do you agree with Webster's dictionary that initial means the beginning or the start? Do you agree with that?
I agree.
And do you agree that when you first started, what you testified that you worked DOE for a year, then left and then came back?
Correct.
So when you came back, when you first came back to the department, do you agree that you were placed at the same step as in-service teachers with equivalent years of service?
I was placed. Yes, I was.
Thank you. That's all I have.
Mr. Reid, anything further?
Real quick. Were you placed in the same step as incumbent teachers as a part of the repricing process?
Could you clarify that a little bit?
When the repricing process happened, were you still in the same step as a teacher with equivalent experience counting your 6 years?
No, I wasn't.
No further.
Since it's almost noon, we're gonna take our lunch break now and then continue with any questions from the board members for Ms. Campbell. So we'll recess and return at 1:30. Thank you.